Protecting your assets in divorce can begin before you say I do. No one getting married wants to plan for a divorce, but given the high divorce rate, no one can accurately predict that divorce will not be part of their future. If you have children from a previous marriage, a family business, or other separate assets that you would want to protect in the event of future divorce litigation, entering into a premarital agreement may be an option to consider. A premarital agreement is a special type of contract recognized by North Carolina law. Parties to a premarital agreement can agree to virtually any terms, so long as the terms do not constitute illegal acts and are not against public policy. Parties can agree on how they wish to divide marital property should they divorce. The parties also can agree on the amount of alimony a spouse will receive, or whether he or she will receive any alimony at all. The only limitation is that a judge may override the premarital agreement if a dependent spouse would be eligible for public assistance upon separation. For a premarital agreement to be enforceable, that is, valid in a court's eyes, certain legal requirements must be met. First, both parties must enter the agreement, sign the contract, voluntarily. Courts generally interpret this requirement to mean that the parties clearly understood the terms of the contract. The written terms were accurately representing their intended agreement, and neither party was tricked, forced, or coerced into signing. Second, both parties must fully disclose their assets and debts to one another before signing. And third, the contract must not be what the law calls unconscionable. An unconscionable contract is one that is procedurally unfair and in which the terms are so obviously unfair that they shock the judgment of a person with common sense. For example, an unconscionable contract would be a one-sided contract that the other party was tricked into signing. If you are interested in having a premarital contract drafted, you may wish to advise your fiancé that he or she should seek the advice of another attorney. North Carolina courts consider a number of factors in determining whether a premarital agreement is enforceable, and one of those factors is whether both parties were represented by independent counsel. A word of caution: premarital agreements generally involve complex areas of law, equitable distribution, spousal support, even constitutional rights. Whether you wish to have a premarital agreement drafted or your fiancé has asked you to sign one, seeking the advice of an attorney is an excellent idea.